Welcome back, Crime Spies. Hello. Oops, am I backwards? Hold on a minute. There, now I'm not backwards. Welcome back, Crime Spies, to day 2 of Justice or Injustice. And spoiler alert, it's an injustice. For starters, I would like to let you know that according to the date calculator I used yesterday, today is day 1313 that Zachariah Anderson has been behind bars for what I believe is a crime that he most definitely did not commit. Number 1. Number 2, I'd like to thank the sponsor of my wardrobe today, Mr. Steve from Publicly Buzzed. Ooh. For those of you who don't know, Steve is friggin' awesome. He has a channel on YouTube. I'm hoping he switches over to Rumble one of these days, because I'm telling you, the true crime community over there is growing in leaps and bounds. I'm really hoping we break through with this series, Justice or Injustice, the troubling trial of Mr. Zachariah Anderson. So what I wanted to do this morning is kind of pick up where we left off yesterday, which was opening statements. The gas bag Gravely finished up his opening statement in day 1 of this trial. And then the defense attorney, she began her opening statement, and the gas bag Gravely interrupted, and they took a break, and the judge is in the middle of a speech. So I wanted to get this done and then conclude with her opening statement, which from my understanding is day 2 of the trial. I'm a little teeny bit confused. So for those of you who are joining me today, if you're more familiar, I'm trying to keep track of the days by her outfit. Like, she goes from what she's wearing, which I think is black, and then she finishes her opening statement in like a tan colored blazer, and then she's got on like a bluish, like a robin's egg blue colored kind of blazer. So I'm going to bring up, oh, I should have done this before. My apologies. Oh, and I bet lately I've been getting the YouTube thing where it tells me I have to. Hold on a moment. No, I gotta grab my phone. Please hold on. For some reason, every time I start up my browser on this computer, YouTube is now asking me to authenticate my identity. Please hold one tiny moment. Okay. This just started happening like the last couple days. Oh my goodness. Please hold. Your viewership is important to me. We will be with you in a moment. And also, hopefully, I turned my microphone down because when I listened to part of the replay, I turned it up a tiny bit. When I listened to part of the replay, it was kind of buzzing. All right, let's try this. Yes, it's me. All right, are we in now? All right, and I'd also like to thank Vielhammer Media. His credentials are in the description box underneath. He has worked his magic with the audio. What did I say here?
The history of the case determined pre-trial.
Okay, so we ended at the 254 mark. Dun, dun, dun. Right about here. All right. Live stream cut. I'll fix the window underneath me with the YouTube chat once I get that far. All right. Thank you for joining me. And nothing would please me more than if we could get some eyes on this this trial over the holiday. I know a lot of people take vacation over the next couple weeks. As I mentioned yesterday, in my opinion, like when the Rona was raging, a lot of people were like tuning into the Tiger King thing on Netflix. So not necessarily Crime Spies channel. Frankly, you might want to watch somebody who is like an attorney watching this trial in real time. But it would be really nice. The trial is 17 days long. Each day is like close to 6 hours. And I plan on doing it as much as I can over the next couple weeks. So, all right, here we are, people.
And as long as there is some evidence to directly connect a third-party person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible. By illustration, where it is shown that a third party not only had the motive and opportunity to commit the crime, but also was placed in such proximity to the crime as to show he may have been the guilty party, the evidence would be admissible. Or where a third party has committed or actively seeks to commit violent acts against the victim, or has threatened the victim in a manner not remote in time, place, or circumstances, evidence might likewise be admissible. Place or circumstance. Yeah, I commented last week. I didn't
look
think
at
that
wait, my sister from another mister is here. Let's go through this. Botrix is here. I'm not really even sure what Botrix does. The only reason I added it is apparently you can do like, games on it. Jamie, hello. Chrissy is my sister from another mister, and frankly, Jamie, you kind of like round out the trio. I mean, I do have triplets, so I do kind of like things in threes. Eris is here, my very first moderator. Eris, you're like some kind of wizard. I must get your address and send you something out of my big giant crochet pile. Nancy RN, good morning, almost afternoon. Hello, hello. All right. I'll get the chat put up on the screen. And Chrissy, so the plan is I want to get through the opening statements before Sal starts his Mark Jensen live stream. And then this afternoon, I think it's day 3. I mean, from my understanding, and I could be wrong here. I think it's my understanding that day 2 is kind of short. I don't know. Like I said, I'm using the defense attorney's outfits as a guide. So Chrissy, if you're available this afternoon, I believe I scheduled it for 3:30 Central Standard Time, which I think is 4:30 your time. If you want to join me, I can switch this to the Restream studio so I can invite you as a guest. Let me know. Okay, here, let's go so we're not late for Sal.
Campbell, thank you. Case met the standard from what I've heard so far, and this is not a ruling. This would be a much stronger case. for the defense.
Yeah, I maintain a high degree of confidence that the court's mind will change when the court hears the circumstances, but that will be.
That was the mistake that I'm not commenting for precedential purposes, but that was the mistake that the very good judge in the case from last year made.
Even though that mistake was made previously, I maintain a high degree of confidence that when I have an opportunity to appropriately investigate this, and the court hears the factual circumstances of this scenario, just as the court did in Campbell, the court will find this to not meet the standard of Denny. I have a high degree of confidence of that. That the court.
I want to pause for a moment. The one thing I did forget to do was add the link. Someone in the chat yesterday, pardon me, I'm old and I forget people's names, but someone in the chat yesterday had mentioned that MLS Making Law Simple David has a really great explanation of this Denny law ruling thing. And I had meant to add that link in the description. I will do that.
Court will not find a motive and will not find circumstances that are worthy of a jury actually hearing that accusation made. And I fear that there are additional candidates for Denny consideration. And so, yes, I intend now, I evidently was fooled by the idea that a Denny motion was filed against one individual. And maybe that is my error. Maybe I should have understood that when defense counsel chose one person to file Denny and then made Denny arguments on another person, and I believe intends to do additional based on the representations they made previously, I didn't know that they were only going to litigate one and not others.
Well, I'm not suggesting you did commit an error.
Well,
but you did not. We're not on the same page. No.
I've never filed that. Never filed a pre-Denny because I've never faced defense counsel before where I felt that was enough of an issue that I would. But I certainly will this time, and I certainly adopt the court's idea that in certain circumstances, when certain things have happened, that the state has an ability to force this litigation to occur. So I'm going to do that. But, Your Honor, we are in the same boat here. I don't know who will be the next argument that is made. This is an argument that cannot be taken back from the jury. I am requesting a mistrial, an opportunity to do the appropriate Denny investigation and have the appropriate Denny motion filed, and then let's litigate this.
Judge, if I may.
No, Judge, we can't have multiple attorneys.
Well,
just pipe down,
my
sir.
feeling is the reporter can decide.
What's good for the goose is good for the gander.
Sometimes it's just a constant barrage of remarks coming from one table or the other, and the reporter can't be expected to handle that. Where it's segregated enough, would it present a problem to have another lawyer address this? Okay, go ahead.
Thank you, Judge. And I'm not trying to barrage. I've been quiet as a church mouse, as you saw. So Mr. Gravely's wild imagination about all these Denny motions
You
that
need
are...
to have the adjective in there.
I'm sorry?
You don't need that adjective?
Okay. The imaginative
this is not
discussion about this motions that...
Okay, you let the gas bag go on for a while and you don't reprimand him. This is so troubling on so many levels. Again, like, I just can't think about anything. And I don't know, there are some of these like black, like short blips in the video. So I can't help that. And I also, for your viewing pleasure, added Vilhammer's logo at the bottom right because he's like a wizard and it is his video. He does have a little thing in my outro, but anyway.
That he thinks is coming is it's a little bit mind-boggling because he now says that after hearing this text that we got from him, Judge, that now he wants to go investigate, and that he's confident that he's going to prevent a Denny motion or defeat one. Well, we've made it clear we're not doing a Denny motion. We're not doing one. If you read the context of this transcript, it is Ms. Mueller saying the police investigation's poor here. They missed this. They missed this. They missed this. And then she talks about the transcripts. The texts. And so, and if you remember, Judge, during our last trial in this courtroom, it was the state that suddenly had some information that would come out during his opening that we found out about. That's what caused the mistrial then. And then, following that, with quite a bit of litigation to follow, they did their investigation. They followed up on that investigation. So it's the same refrain right now that we're hearing from the state's table, the exact same thing, that they're caught flat-footed about stuff that they should have known about, and we're calling them out on it in our opening and in our argument. And that's what this whole case is about. This isn't about 10 different Denny motions. If we wanted to bring 10 Denny motions, we would have brought them. I think this court has seen that this defense team has been absolutely meticulous about bringing things to the court's attention, about litigating things properly. There's no misconduct here. There's nothing underhanded, and there's no attempt to bring a subvert Denny motion. And the accusation, it seems almost like the state wants to take this case because they know that it's weak.
It is weak.
That's what it looks like from the defense table. So I'm going to ask this court.
Pause one moment. For those of you who didn't watch this with me yesterday, hindsight. Okay, so this same judge was the judge that presided over Rittenhouse. And for those of you who watched the Rittenhouse trial, that was, I actually didn't watch it because I was so nervous for him. But the jury there got it right. Easily could have gotten it wrong. So in hindsight, can you imagine if the state did get their way and did get a mistrial and got a more critical thinking jury in? This could have ended, the way it should have ended here. Apparently it had fallen down, go boom, accident, and that messed up his head. Oh, goodness.
To deny the motion, instruct the jury to say, just like Mr. Robert was saying, to say opening statements are not evidence, period. Okay? And then we'll finish our openings and we'll get on with it.
I'm really trying, I really need to not interrupt this so we could get it done before Sal starts, but it sure seems to me that during the Purse House trial and also, the judge was different in Rittenhouse. I've seen this guy before. Wait, he might have, maybe that is true. Where was I going with this? No, I forgot. Okay, never mind. It'll pop as soon as Hi, Valhalla awaits. Somebody in here hasn't hit the like yet. Don't be that guy. Yeah, I got 30 likes yesterday. Okay, granted, one was me. That was incredible. Hello. My daughter, before her and Truman left, they said, Mom, I got your notification. Because, she's 17 and she's had millions of views on TikTok. So I'm like, you need to share I told Truman too, her boyfriend, you guys need to share this with your parents and your grandparents and those over the holidays to watch this. I mean, I refuse to go on TikTok because it's, CCP, but this is just so important. All right, continue.
The particular problem for me, one of the particular problems for me is, and I'm sure I commented about this before lunch, is I certainly agree that it's our law, and it has been for a long time in this country, that the defense has the right to pick away at the caliber of the police investigation. And some of the points that have been raised by Ms. Mueller have been along that line, and this is certainly one of them. At what point does the camel's back break? At what point does legitimate picking
Judge just made it funny.
at the caliber of the investigation become an accusation of another? You know, this would not be this big of an issue in the case if this just arose during question and answer of a witness, and there being an objection, and then I would have to make a contemporaneous ruling, and we might never even think of it in terms of Denny-type motion. But unfortunately, I understand your position, and I wish this weren't arising now, but there is a point at which the additional weight of the additional issue created by this messaging, along with the features that go with it, would or did break that camel's back. And what do I do when this issue arises in opening statement? Do I
Sir, I think
say,
you look like
if I
you've
think that
had
this evidence is
several
going to be
years of
admissible,
experience in this kind of thing.
do I rule without considering its cumulative effect, which maybe deciding it is Denny material, or and that's what you claim, because you say in the end they're going to be pointing fingers and citing all this evidence, and I can see your point that it becomes Denny type evidence, or I can hear what the defense is saying, and just let it in as evidence to support their claim that the investigation was not properly done.
Well, Judge,
Now, here we are, because it arises now, we have this big issue right at the beginning of the trial, and the jury's been told you have 2 weeks and maybe an extra 2 days.
Holy moly, Solomon is here again. Sir, thank you for gracing us with your presence yet again. And also, please share with your brother. You know what? I actually should have had Lily and Truman film a little message. Maybe I'll have her do that. Does he get, like, can you share with him, like, video messages or anything like that? Because from what I read yesterday, if you mail him something in the mail, it has to go to, like, Maryland or somewhere, and they photocopy it, and then he gets it. So, which I'm going to do. Remember, it's time to buy some stamps. But if there's a way to share, like, video messages with him. Again, today is day 1313 that Zachariah Anderson has been incarcerated for a crime he shouldn't have even been charged with. Okay, continue. And I did drop the link to the merchandise. Chrissy and others, I need to finish my cart.
Days beyond that, and we got to get this case done. And I think, well, if anybody is talking about adjourning this case for more than a day or so, the answer, unless you have some compelling reason I haven't thought of, is going to be no. I have no desire to mistry this case, and because I do think that taken individually, and you know, as I think I commented yesterday, or maybe in the motions last week,
He can't
You
even
people-
remember.
lawyers in general
If
come to
anything-
court thinking the judge has this enormous wealth of evidence, knowledge about the
Wolfram is
case.
here. Hello.
And that is very untrue. I don't doubt for 1 minute that every one of you has 10, 50, 100 times more information about this case than I have. Judges very seldom see much before the trial starts. So
What is
you
the-
say this is, you suggest that this is all going to be easy to destroy, these points that the defense is raising. Well, I don't know that. And and then it's all going to turn into a massive Denny-type attack. I don't know that either. So I have to make rulings on, is this legitimate inquiry into the caliber of the police investigation? And
So, can I just say,
Yeah.
Ms. Jekyll, the person who's texted back and forth, is on the defense witness list. She's been served by the defense. So this is not just an innocent kind of, well, why didn't the cops do this inquiry? This is a subpoenaed witness who's on their witness list. There's no other reason that I'm aware of that she's a witness on their case. And Judge, I didn't object.
well, why did you think she was on their list?
Well, because they have subpoenaed 150 people, and because of those 150 people on their witness list, this is a dear friend of hers, and but they have not spoken to her. They've had no conversation with her about this case.
I hate this
They
man
have
so much.
when she, my understanding, again, this is anecdotally, is when she asked why they wanted to talk to her or why they wanted to subpoena her, they did not provide information regarding that. Judge, I did not object in this case and say to the court that I needed to object based on Denny until point number 5 of this transcript came up, which is drawing the line the full circle. So said, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And then the immediate answer to that is, what's 1 week later? That's when she's at Gutierrez's apartment. So it is a suggestion that goes full circle from beginning to end. And Your Honor, I believe Your Honor is presenting the parties by saying, yes, a Denny motion should have been filed. I think the court is saying that. I may be misunderstanding the court. And there is no remedy at this point for the court. I'm not asking for an adjournment, Judge. I am telling the court improper information has been provided
you're
because
yelling.
the court has not heard this in the way that Denny intended. And it fits all of the qualities of Denny. It's not. This is not just something that came up in the middle of trial under somebody's questioning. This is a deliberate presentation. This is an argument structured by a lawyer that began by saying suspicious person, first person to discover Rosalio Gutierrez's bloody crime scene, text with her, conversation with her friend or dear friend on our witness list, turns out, and mystery, it's been taken care of, call me in a week, and then guess what they say happens in a week? She shows up at the apartment and finds the crime scene.
Huh. In my opinion, an adequate investigation would have gone down that road. Thanks for reminding us.
She's described as a conspirator.
I've already stated that I
Yeah,
thought
and
so this was a stronger case than the case on which they did bring the motion.
But the court has not heard the Denny criteria. The court has heard one very specific set of facts without the state having any ability so far to respond.
That's where, no.
Okay,
Here.
and the court is.
No, Mr. Grable.
I apologize.
This is the mistake that a very capable judge in Milwaukee made that I've mentioned. Should have waited till the smoke cleared. You made the statement before, there's no other remedy. That's not true. Some of them are not remedies I particularly want to do, like telling the jury, guess what? Your plans are all off because you have to sit home a day or two while we deal with some legal matters that have just come up. I investigation and resolution have got to take 10 days or 5 days.
Again, I don't know what
And we
those
squeeze
little
it
dark
into 1 day.
pauses are.
And I don't think that, I don't think it's outside my power to command the defense if they have any that they need to communicate them to you by 9 o'clock tonight or something, I don't know, and save the trial. I think that declaring, I think ruling this a mistrial on the basis of what's occurred here, without knowing whether this will ultimately all be determined to be admissible, which is one of the mistakes that my friend made, and making a determination that something was a manifest injustice when there were other things that could have been done. I think that's a mistake. So I'm not asking that you agree with me or change your mind about anything, but I want to hear from both sides here. Without ruling on the pending objection, I'm thinking in terms of sending the jury home until Thursday. Today's Tuesday, right? Thursday, and then we'll pick up from this point, and at that time I'll either sustain or overrule your objection. And me direct Ms. Muller to move on to another subject. We'll have, I've already canceled or in the process of canceling what was left on my calendar for tomorrow.
So,
And so I'm available to hear these things and determine them, and then I won't get in the boat that the poor judge in Milwaukee got into.
so
Well, if I could, Judge, I think.
Well, yeah, you did speak first. Go ahead.
Yeah, I guess I'm a little confused about what it is that the court is going to wrestle with in the next day, because if it's, well, I'm going to listen to the defense's Denny motion, there is none. So,
Constructive Denny motion.
I'm sorry?
Or do you prefer virtual Denny motion?
Okay. All right. Well, if that's the case, then maybe we need a week. I don't know, but
Well, you're not getting one.
I know. I know. So what you're saying, this is, I just want to understand where the court's at. You're saying you want to have a hearing on what was said in opening in the greater context of what the actual evidence will be?
Well, what was said at opening is significant only because it creates the problem that I was discussing at the beginning, that this is time for something like this to come up. And that's really not the focus. I mean, if there's a misstatement made at opening, it can be dealt with, whether it's by a corrective instruction or whether it's by a mistrial. Made very clear he's willing to run the risk. The issue is he's painted this portrait of what he thinks is unquestionably any type of evidence being used for the very purpose that the Denny rule, what's the terminology that they used? I read it before. Legitimate tendency.
Pause. For those of you on Rumble, I'll be there eventually just to say hello. But the chat on YouTube is underneath. And hopefully you're reading it and will engage in the conversation. We do have the defendant's brother in the chat over here. Fainting over here. Crime Spies is. Just a wonderful, wonderful man and family, and seriously, our hearts just break for these people. Also, please, so for those of you on Rumble and Kick, actually, if you could please engage in your chats, and I can add those somewhere on the screen here. But Soloman is helping us out as this, windbag Gravely, the prosecuting attorney, overeager a-hole, and the nincompoop judge debate.
Ultimately, I need to make a ruling whether you can present your Denny type evidence in either as a full Denny attack or in some truncated fashion as proper cross-examination, but not suggesting an alternative actor to the jury. So that's the big question, and that's where I said that's where my friend strayed, is he declared the mistrial before he had the Denny hearing.
But Judge, why would they file a Denny motion when they've already accomplished what they wanted to do? The jury has heard this information. Again, this can't
if I decide that the Denny motion is granted,
yeah,
then they're going to do exactly what you most fear, is they're going to present an alternative actor defense. If I say that that the evidence does not support what you claim to be an alternative actor theory, then, as I said, they're either going to have to eliminate or truncate the evidence that they were going to offer that would constitute a Denny-type defense.
Okay, so what has been
I feel free to say I don't know what you're talking about.
Well, I'm trying to figure out. So I don't see any motivation for the defense to file a motion. I think they've clearly stated they don't wish to or intend to file a motion. I guess I could file something, and I think the court is telling me that I would have a portion of a day to provide the court a response. I think that's the guidance. If I understand where the court has told me we're going, and that the outcome of this, when I have requested a mistrial, is that there would be the court believes that perhaps some cautionary instruction would be the remedy, or they would not be allowed to pursue this in other avenues.
Well, the bottom line is this is going to defy any precedential solution. I don't think this has ever happened before. We went through that on the Campbell case, where you couldn't find any authority other than down south.
Right.
Sorry.
So the worst, to me, I'm standing at the edge of the Grand Canyon, and you're asking me to take the high risk that you're going to be able to knock down this this Denny notice that they've not given, and everything will be fine. That's what happened to the poor judge up in Milwaukee.
And in that case, Judge, just so that we understand the historical reference that I think the court made to us, are you saying that that case was dismissed without prejudice?
When I'm talking, this secret case I'm not naming?
Yes.
Oh, his
Dismissed
secret case he was
with
waving
prejudice.
around.
Okay. So
By the Court of Appeals.
Okay, because I've
Dismissed
litigated
without prejudice by the trial judge.
All right, so I've litigated this issue in our courts here in Kenosha before, had it gone to the Court of Appeals and did not have that outcome. This was several years ago. It was in front of Judge Milosauskas, but I had a case in our county where this occurred, and not where Denny was granted at the end. So I understand that that would be the distinction.
Is it reported?
No. But it is a case that I had. I had it with one of the Jensen co-counsel from the Public Defender's Office, who still works at the Public Defender's Office. But she, in an opening, did the same thing. But, you know, again, I'm not citing it for presidential value. And again, I did not have a post-mistrial granting of the Denny. So it wasn't, you know, I think the court is adding that aspect.
Well, if the judge in the case
How come
I've
he doesn't get
spoken of
reprimanded for
had
being a
not made that
smart ass?
determination, I assume the Court of Appeals would have made it for him.
Okay. You know, what the court has before it right now is an offer, what I would call a Denny presentation by the defense, where the theory that is proposed is that this person, you know, from my perspective, what has been argued to the jury, I know the defense says, well, we didn't argue that, we just argued bad investigation, right? But what I believe has essentially, what we know, points 1 through 5 that I cited earlier, is that the idea is that a person who is having an active relationship with this individual, who on May 17th,
He's arguing the reason why
the
she
very
should have
same
been
day that she has
considered.
contracted for his murder, the day before she has visited his children for the first time,
He knows.
and the day of, she is literally texting him, I want to take this relationship farther. I'm hoping we can take
and
this
he
relationship
changes
farther.
his.
Where
he
in the
changes his
meantime,
tune and asks her about
she
the
has
weather.
conspired with her
at
friend
Zach.
to have him murdered, not because she has anything against him, per the defense representation, but as a means of framing his ex
Look at
because she
that
is
face.
frustrated that he is monitoring her in some way she can't prove. That's the factual circumstance the court has. So the motive the court would consider.
I'm back at the same place I said before.
Yeah.
I don't have all the information that you do.
Right.
So I don't know.
That's my point, is that
And
I
I'm not-
haven't had a chance to make that argument to the court because we didn't have a Denny motion, right?
This judge here
We're-
All right,
is
that's what I
unfit to be
appreciate. I
sitting on
told
the
you
bench.
we can have one now. And I don't know what happened downstairs in that other case, and I don't know anything about it, and it's not reported, so.
Sure.
Well,
But let's hear from the other side.
just judge it.
Oh, finally.
I don't know how much a briefing or whatever needs to be done on this. I think if we print
Hello,
off
David.
the entire transcript of Ms. Muller's opening, so you can see the entirety of these very tiny comments in that whole larger context, it will be pretty clear that what we were saying all along is that this is just about a shoddy police investigation. It's not trying to point a finger at a third party. We would have, if we wanted to do that, Judge, as you well know, we would have done that.
Well, I have the good fortune that I have a splendid court reporter who came into my office right after we broke and said, would you like me to go back a little further? And I said, well, yeah, if you've got the time. And she presented me with a longer transcript, so I have a better idea. And I was listening, by the way.
Yeah. But I think that'll make it pretty clear. In other words, we don't need to have some big factual presentation beyond what's in that transcript. It seems to me that that's going to clear this up for the court.
I'm not going to comment. I don't know what the future holds. I certainly would not have predicted when this day began that I'd be dealing with this issue right now. But consider yourselves as having filed a Denny motion on with respect to Ms. Beecham. And if you have any others who need to state those, what did I say, 9 o'clock?
Yes?
9 o'clock by message to the district attorney, electronic, and to me. And the DA can have until well, we'll start again at 1 o'clock tomorrow.
What time is 1? How do you
And I'm
spell
not going
that,
to
sir?
put a deadline for you to file a written response. You can just,
Is that a flip phone?
We're going to start with legal arguments at 1, or
we're going to
start
start
with the
with
jury at 1?
whatever anybody wants to say on this issue.
Oh my God.
I assume there's going to be a lot of
This is
legal arguing, but
disgusting.
if you want to offer testimonial evidence, we'll do the best we can.
This must be why she
So
changes her
today
outfit
I
3
believe the
times.
court's denying my motion for mistrial, if I
No, I'm
understand.
not.
I mean,
I wanna get on
provisionally,
speeding up.
provisionally.
I wouldn't say that.
Okay.
I wouldn't say that. I would say,
I wasn't trying to cast his
No,
version
no.
anyway. I just was trying to interpret how the court is, where the court is
Well,
postured.
God, this
Yes.
guy needs to shut up.
I have not made a decision
Okay.
on that, and it,
And that is what we're litigating in part tomorrow at 1 o'clock. Is this issue of
and
whether,
I assume I'll make some decision about whether we go forward or not, and under what circumstances, and give you some guidance about what and would and would not be acceptable evidence out of what has already been mentioned.
so of course we're going to start having witness crunches, and the court, that's not the court's problem, but it is
Thank you,
ours.
Iris.
So
Thank you so
am I
much.
to have no witnesses available tomorrow? My witnesses would again be available for Thursday? Is that the guidance?
Yeah, because I'm not going to have the jury come in tomorrow.
Okay. All right. And so we will litigate my motion for a mistrial as well as the Denny issue at 1 o'clock tomorrow. Do I have that correct? Okay.
It's all about you,
And
sir.
if anybody has a
Said no one
witness
ever.
who absolutely, positively has to be heard tomorrow, tell me that right now. Because it's not that I can't have the jury come in, but at this point, it doesn't seem there's any sense of it.
So Michael Campbell is a witness who is headed to Florida on a planned vacation. Remember Michael Campbell? We've mentioned his name a few times.
I've heard his name before.
So he is headed for Florida on
Sorry, I
a
had to
pre-planned
jack the
vacation.
speed up.
He's leaving on Thursday to go on that vacation. I just asked if we could figure out when he gets back. I don't know if we know that. Okay, so we're checking to see when he's back. I don't know how long it is. He's the only one I know is an issue for Thursday on.
You know, I'd probably be in prison if I was a member of Zachariah Anderson's family for sitting through listening to this jackass gravely gas bag
If I could inquire maybe like when that transcript would be done,
a-hole, if you
if
will.
that would be done, so we can work on it tonight, tomorrow? Perfect, thank you.
Okay, how lucky am I?
You don't
My
get service
very
like that
first
everywhere.
No, you do
moderator
not.
was Eris, and my second one was Soloman Anderson. Am I dreaming? I need to pinch myself.
Okay, so we have a witness who will be gone physically Thursday, Friday, but he's returning back to town by next Monday.
He's the kind of guy that if I knew him in
He's the only witness
person,
that
I
we
would
know is an
avoid
issue
him
for
like
us.
the plague.
Okay. Defense, any witness issues?
Sorry, I just wanted a clarification on what exactly the court was ordering the defense to provide by the state. And I'm assuming it was by 9 p.m. or 9 a.m. tomorrow?
It was 9 p.m.
Okay.
And it was any persons where you propose to offer alternative actor evidence in terms of
Here, let me open up my file cabinet.
death of Mr.
I'll give you a couple,
Gutierrez.
2, 3 people.
The state says there are all kinds of people. I have to tell you, I deal with a lot of people with bad reputations coming through here over the years, and this is a first for me to have that many people who would be considered as. You said there were going to be a large number of people who were going to.
I thought I heard a representation. I was basing that simply on the defense indicating that they had some more people that they were about to make a similar argument at the point that I objected. It was just based on the defense. I believe
Because there
indicating
is.
that. And the track record of Michael Campbell indicating that we had a motion, and then this case where, from the state's perspective, to accuse Sadie of being a suspect in this homicide, counsel discussed what he felt was mind-boggling. This is my mind-boggling episode. So it dramatically increases the number of people who I see as potential suspects if that is the quality of the theories that are being provided to the court or to a jury. So I rhetorically said that it appeared to me that there were a number of others, but I may be wrong. They may provide no additional individuals, which would be fine.
So what it sounds like, the state would like to.
Okay, I'm just going to pause again. For those of you who do not know or aren't familiar with this complete miscarriage of justice, this is an injustice of the highest order. Whatever this windbag here with white hair, this jackass a-hole says that he's arguing is basically the truth. Like he's spelling it all out, in my opinion. He knows for a fact that his case is garbage. He knows for a fact that the investigation had tunnel vision. He knows for a fact, where is she back here? Is she in the peach colored, or no, this is her here. He knows for a fact she should have been investigated. I mean, again, I just started following this, like educating myself on it. And there's like a whole filing cabinet full. How in the world Zachariah Anderson even was arrested? Or, I mean, maybe I can understand him being questioned because he was, had a long-standing relationship with this woman here. But I don't understand.
Take all of the points of the investigation dealing with particular individuals and reframe those all as Denny and get you to exclude them so that they don't have to worry about them. That's what I'm hearing. Because Mr. Gravely keeps saying how we are accusing her, and we've repeatedly said here in open court that that's not the case. So you could have a reasonable, we could look at this transcript and the court might read it one way, Mr. Gravely might read it another way, we might read it one way.
Do you want to be
at the
number
end of the day,
3?
there's not,
I don't even know.
He can't just ask this court to look at every single point of criticism of a shoddy investigation and call that Denny.
Without responding to your comment, I would just say that if you do not supply the state with the information about people who would fit into, we'll call it a near Denny category, don't count on any of that evidence coming in. The law is there, the notice required is there, and it hasn't been given, and if the circumstances don't require it to be given, then you're in the clear. But if it turns out it fits into that category of any evidence, it's not going to come in.
I think we have guidance. Is the jury back? I assume they are.
Well, I certainly hope so.
Okay, so
I could use a little more guidance though, because perhaps what you're asking of the defense then is for us to bullet point for the court each of the points of our criticism of their investigation and who's involved. Is that what I'm hearing?
No.
No? Okay.
Well, you may be hearing that, but that's only your imagination.
Okay.
I did not say that.
Well, I would just like to know what you would like to see.
Yeah, and I actually thought it was clear.
If I can, my understanding of the situation is that you would like the defense to provide, if we're going to have any other named individuals who we intend on presenting in the same way that was presented as Sadie Beecham, that those people should be provided to the state by 9 p.m.
Let's do it this way. Let's just pretend that I tell you need to comply with Denny, the Denny rule,
Listen to
legitimate
this.
tendency.
Sir, it's
Except
not what you're
that
saying,
the
it's your tone.
provisions that you bring the motion and have it heard before the trial have been changed to tomorrow. That's what the order is.
So who they are and what the factual circumstances are that meet Denny.
I think
That's
that's,
what I hear.
I think that's fair.
Thank you.
And he
Right.
just continues. Okay, I think we're finished with this guy.
Well, let's get the jury down.
Oh,
Oh, my
man.
goodness.
Here, let's take a gander at this poor man who's been behind bars for 1,313 days, which equates to a little over 3 years and 7 months. And he's been sitting there day after day after day for something he's not even remotely connected to. This is horrifying.
All right, folks, I apologize. This happens rarely. And there was an objection made.
Oh, he's talking to the jurors. Okay.
I'm going to
Quiet.
stop it right here. I'm not going to rule on the objection right now because actually I'm going to take some more argument and perhaps evidence tomorrow on some issues. And that will hopefully assist me to resolve the issue that's pending because of the statement in the motion which was made. We have a very shortened schedule. These are usually things that are done prior to the trial, but and we're going to condense them into one day tomorrow. And the good news for you is you don't have to be in on it. So I apologize. I know it's disruptive to your schedules. And of course, it means that the case may go longer. But I still hope to finish within the 2 weeks and 2 days that I had hoped was the outer limit. But this may resolve a lot of issues in the case, what comes out of the hearing tomorrow. So I'm going to ask you to return Thursday at 9 a.m. It is critically important that you not read, watch, or listen to any account of the trial. Discuss it with anyone. It may or may not be available for viewing on the internet or television or anything. But it's not available for you. Believe me, that's totally critical to this matter being resolved fairly before this jury. So do not read, watch, or listen to any account of the trial and don't discuss it with anyone. And does anyone have any questions? Okay, so keep your minds open. Don't make any final conclusions from what you've heard so far from the district attorney or Ms. Mueller. And we'll pick up
Hi,
again on
Lynn.
Thursday. Thank you very much. Have a great day.
All right, so someone please guide me. Thank you again to Vielhammer Media for his... All right, so now this is the next one that's playing. Please tell me if this is not in the correct order. Oops.
Back in the appearances
So
you had
see,
before.
no, this isn't right.
And the lawyers were kind enough to take the time to sit down.
This isn't right. She's in some type of tan-colored outfit, I think, to finish her closing arguments.
Down and confer with one another. And there was also a submission
Oh, this
by
is
the
only 10
defense,
minutes.
which I did review. And why don't you take it from there, Mr. Gregory?
So counsel will correct me if I make any representations she did not feel are completely accurate, but I believe that.
You're not making
Apologize.
No, he
I
just likes
believe
to
that
shout.
Based on the filing submitted
Turn
by
you
the
down,
defense,
sir.
that the state and the defense have an understanding that the defense will not make any arguments that rise to the level of a Denny argument and not present any evidence that will rise to the level of a Denny argument. And they recognize that the argument that the state believed was a Denny argument was a sort of a connect the dots argument of some individual pieces of evidence, and they've indicated they will not make that sort of connect the dot argument that would rise to the level of Denny, and their submission reflects that. They have indicated to the court they have no additional Denny hearings that they are seeking from the court, even though the court gave them guidance if there was Denny-like evidence that they should put it in their submission. In light of that and understanding that I believe that to be an accurate interpretation of what they wish their filing to represent to the court, the parties were able to come up with a joint proposed cautionary instruction so that we did not have to have a mistrial in light of that pleading. That joint proposed cautionary instruction has been submitted to the court. All parties have copies. Does the court need me to read it, or does it stand in this record because it is a filed document?
I'll leave it to your choice, or that of the other party. It doesn't need to be, but you're welcome to do so.
Well, I have no reason to. Do you, counsel? Okay, so we've come up with a joint proposed cautionary instruction. We're asking the court that be read at the conclusion of the defense's opening statement. That was the express preference by the defense counsel, which the state is fine with, so that it is in close proximity to the end of the defense opening statement. The court certainly will use its own discretion about whether it should be read at any other time, but that is the time that we are asking the court specifically to read it. The state is also requesting to the court that in light of the sort of connect the dots argument made by the defense, that the state be able to add to its witness list and to call in its case in chief a witness named Rebecca Jekyll, that's J-A-E-C-K-E-L. We intend to present some evidence to refute the implications that were raised in the defense opening argument. And I don't believe the defense has any issue with that. I believe that's the entirety of our discussions. Is that, counsel, does that? Yeah. So I believe that is the entirety of our joint discussions.
All right, is that a fair statement?
Yes, hold on one second.
Yeah.
Okay, so I just want to be clear. The video I didn't watch, but like had kind of queued up a little bit, was this defense attorney. See how she's wearing like a bluish colored blazer? She finishes her opening arguments in like a tan colored blazer. This video here is only like 10 minutes. Just, okay, thank you, Jamie. So then after this 10-minute video, it should go to her in the tan blazer, finishing her opening arguments, ? And Jamie.
All right, so is that a
I
fair
love
statement of
vanilla
the
too.
situation?
Yes, with some caveat, but it is a fair statement. The caveat is that my conversations with the district attorney, as it relates to how I could perceive how he interpreted the statements made in my opening statement, I had told him that I could see how he would interpret it that way and how someone could interpret it that way, but that I'd hope he could see that we could also interpret it, the defense could interpret it in the way that we so proposed on Tuesday and also in our pleading to the court. And so there was kind of that mutual understanding that it could be seen both ways is kind of
Thank you, Alicia.
my understanding of that conversation. And so that was why we found it amenable to prepare this proposed cautionary instruction, and that would really cure any concerns that the state would have as it related to the statements that were made during the opening. As far as when we are requesting it to be read, the state's assertion was correct, that we're asking that it be read at the conclusion of the defense's opening statement. And then with Ms. Rebecca Jekyll being added to the state's witness list, naturally no objection. She was on ours. I did confirm with the state that they will write up a summary of what was discussed with her about this text message that will be prepared and provided to the defense prior to her testifying, so we will have that information and can act accordingly when we receive it. So that's the only supplement that I have, Judge, but I think that what the state and myself have come to an agreement on is appropriate, and that the court should accept it and should allow this trial to continue.
So they were
There's
able to.
withdrawal of the motion of the
Yeah.
state for mistrial?
Frankly, what we've tried to figure out is a way to move on
I
at
know
this
how you
point.
can
So yeah, I'm
negotiate with
withdrawing the
this
motion
guy.
for mistrial in light of the stipulations and the filing so that we can keep going.
What did I do in my life to merit such congenial attorneys?
Oh, Judge made
no,
another
this is,
funny.
well, I'll leave it at that. Now, this is not something which would reach an element of the offense. Well, that's the wrong reach. This doesn't actually constitute an element of the offense charged. So I don't think we need to obtain the consent of the defendant, but I assume he's familiar with the agreement and what it means, and if you want to discuss it a little bit more with your attorneys, you're welcome to do so.
If we could just have a brief moment. Naturally, I was not able to confer with my client. Can we go in the back?
Yep.
Thank you.
Okay, now what happens? Look at him.
You know, I didn't tell the jury yesterday, I usually do. But, and I will tell you that a former member of your office, before the time that you were the high muckety muck,
Hi, muckety muck.
Ancient times.
actually ended it, what's that?
That's-
Ancient times.
Ancient
that in
times.
law school, that
Actually
phrase,
walked
high
out of
muckety
here
muck?
with a negative score for the year. He's a very bright individual,
It doesn't sound like it.
well read, but he's impulsive and he guesses too quickly. All right, I guess we got to go to work.
I have a couple of theories, but
Yeah, I don't think either one
Oh,
of
you
you are
had a
funny.
chance to talk with your client?
Thank you. Yes, Judge.
Okay.
Oh, sorry.
Do you have any questions about this at all, Mr. Anderson?
No, I'm good, Judge.
Okay, any problems? Okay. All right.
He has a really low voice.
back at 9.
I think I've
I
never heard him
will
speak before.
accept and approve the stipulation, and it will be given as you request. If I remember to do it, at the close of your remarks, and if I do forget, just
I will remind you.
remind me. And other than that, I think back at 9 o'clock. And anything else?
No.
Nothing.
All right.
Thank you, Your Honor.
Enjoy this magnificent day. First day of meteorological spring.
Oh. Judge is also a science major. All right, let's see where Veilhammer Media is going to take us. Again, thank you so much for modifying. Okay, this is day 3, Lori. I don't think this is right. Where's her in the tan blazer?
Anything before I bring the jury
Oh, there
down?
she is.
Anything before I bring down the jury?
Hopefully this is correct now. So I had the order of her outfits wrong. So what should happen now is she should be able to, according to what I'm understanding, she should finish up her opening arguments. And I think they're like 20 minutes long. Then we're going to stop this live stream and begin with the testimony at 3:30 Central Standard Time. Sal has his Mark Jensen live stream at 1 p.m. Central Standard Time in 20 minutes. And for those of you who don't watch it, you are missing out. Sal is fantastic. And apparently he has some kind of Christmas gift, if you will, for the viewers. And then let's see. So I have a second live stream set up for 3:30, which should be the beginning of the witness testimony. And we'll just keep it going until people get, you know, I know it's almost Christmas time, but think about it. You're in your homes baking cookies and wrapping gifts, and poor Zachariah Anderson is sitting in prison. Sigh.
Want to do that after?
I'll have to-
This
There are several
We'll have to
matters, but
adjust
I
the
think
titles.
that the state and myself would prefer to discuss that after the opening statements have concluded.
All right.
I do have one quick one, and that is that the
Oh,
court
of
yesterday
course.
signed a material witness warrant for a Miss Swanigan. because
I
she had
didn't, but
not-
one of the judges did.
Oh, some other, I apologize.
Judge Welk did.
I thought the court did. We're asking the court to cancel that at this point pursuant to contact with our office when the warrant went out. She is physically here and is at the courthouse, and so I believe she's in compliance with what we were hoping to accomplish. So we'd ask the court to allow that to be dismissed at this point, and we expect her to be a witness today.
Did you have a comment?
No comment.
Your wish is my command. All right. Anything else?
Anything else can wait.
All right. All right, good morning, everyone. Welcome back, and we had some discussion, and then the attorneys consulted, and it's decided that the objection which was raised by Mr. Gravely has been withdrawn. So we'll continue where we were. Ms. Muller, thank you.
Okay, so
Good
this should be
morning,
about 20
everyone.
minutes, and then we'll
So where
conclude
I had
for
left off
now.
when I last was speaking with you all was about how law enforcement in this case failed to actually investigate the events the state assert transpired on May 17th, 2020. How they ignored leads, how they didn't follow up on things, how they failed to look in places that should have been looked into. So I'm going to go into some of those investigative failures now. You'll hear that law enforcement really did no searches of Mr. Gutierrez around the immediate vicinity of Wood Creek Apartments, where Mr. Gutierrez lived. That there's a wooded park area that is property of UW Parkside, and that all that they did with that area was send some drones to look around. But you'll hear that it was forested at that point, because we're in the middle of May, and that they would not have been able to see the floor of that entire wooded area. So law enforcement looked nowhere close to Mr. Gutierrez's residence in an attempt to find potential evidence. Not only did they fail to do that, they failed to investigate legitimate Crime Stopper leads. So people could call in with tips, anonymous or not, and there was this one tip where an individual called in and said, I saw a woman standing in front of Mr. Gutierrez's sliding door on that concrete slabbed patio on May 18th, 2020. And I remember this because she had asked me what time it was. And I knew it was Mr. Gutierrez's apartment because his sliding door is right next to that exit door. Law enforcement got that information and ignored it. They did not follow up. They also didn't follow up on data that they obtained through a geofence warrant. And you'll hear that a geofence warrant is where law enforcement takes a certain area and asks Google to produce all the information and data on people that they know were in that location on a specific date and during specific time frames. And in this case, Detective Carrera had asked for the geofence data on all individuals who were around Mr. Gutierrez's apartment from May 17th, 2020 at 7 p.m. through May 18th, 2020 at 3 a.m. And that Google produced several hits for people that were in that area. And you'll hear that law enforcement did not attempt to investigate any of those potential people who were in the area at the time the state asserts the crime occurred. You'll also hear that Mr. Anderson did not appear in that data. When law enforcement arrived on scene on May 19th, 2020, there were two dumpsters next to Mr. Gutierrez's apartment, and they had gone and looked at them and noticed that there really was not that much trash. maybe a bag, a box. And so they called the waste management company and they asked, hey, when was this trash picked up? And the waste management individuals had informed them that the trash had been picked up earlier that morning on the 19th and that it was sent to Zion landfill in Illinois. You'll hear that law enforcement chose not to go to Zion landfill and search what would have been freshly dumped garbage that could have produced evidence in this crime. And you'll hear that that could have been because Mr. Anderson, the person, remember, that they had chose as their main character, there was no indication that he had ever gone out to Zion or that he had spent any significant time in the Kenosha area. Didn't fit their script. They weren't going to investigate it. They also didn't investigate Pheasant Run landfill. That was a landfill that they had potential information that Mr. Gutierrez's body had been dumped there. They didn't go to Pheasant Run landfill. They didn't talk to anyone in management at Pheasant Run landfill to see whether there was any individual who dumped off trash that Monday, May 18th, that morning. They did not investigate that lead. They also didn't investigate people that Mr. Gutierrez owed money to. And you'll hear throughout this case that Mr. Gutierrez was in an extremely difficult financial situation. His mom was helping paying bills. He was about to be evicted from his apartment. And he had people messaging him about where their money is and how you don't do this to friends. And you'll hear that law enforcement did not investigate a single person that he seemed to owe a substantial amount of money to. And then they also didn't look into all of the women that Mr. Gutierrez would have been talking to or dating at that time. You'll hear that Mr. Gutierrez had several dating apps. They were located on his phone. He had emails from dating websites, and that law enforcement didn't look into any of the chat strings on there. And that's just the tip of the iceberg. What I just outlined for you is just a little sprinkle of an example of everything that law enforcement failed to investigate. But not only did they fail to investigate legitimate leads and potential other suspects, they also failed to effectively process the scene of the crime. They failed to obtain DNA swabs, fingerprints from areas that, according to their theory, the individual or individuals who was responsible for the disappearance of Mr. Gutierrez would have had to have touched or come in contact with. The first thing law enforcement did when they arrived on scene on May 19th, 2020, was they took a video of them walking into the apartment, of Mr. Gutierrez's apartment, and all of the lights were off. So the state claims that there was this
Except for a
blunt force
diffuser
trauma,
that
this beating, someone was wrapped up in a rug.
I'll talk later.
The crime scene was meticulously cleaned up so that no trace of the other people who were there could be found. That then the scene is staged to the point that it looks like a robbery could have occurred. That obviously didn't happen all in the dark, if they're claiming that this happened around 10 p.m. at night. Yet law enforcement did not swab the light switches in the apartment for potential DNA, nor did they attempt to get any fingerprints. In addition to their failure to obtain swabs from areas that could have contained DNA of the people who are actually responsible for Mr. Gutierrez's disappearance, their lack.
I really hate to pause because I know we're kind of crunched for time. There was no fingerprint analysis done. Wasn't there like a Corona bottle and a cutting board with like a lime on it and a bottle of water, perhaps for the guest, because it's my understanding the victim was fond of the Corona? This is a travesty.
Of precision shows immensely in the fact that 9 days after they initially made contact with Mr. Gutierrez's apartment, Mr. Gutierrez's mother Ms. Patterson found Mr. Gutierrez's cell phone in the freezer. That law enforcement's there for 8 days. They'll claim that they searched, they processed, they were very thorough, yet they didn't find Mr. Gutierrez's cell phone that was right there in the freezer or the contents of his wallet that were in the freezer. So they did swab the cell phone for DNA, but what they didn't swab or process for fingerprints were the cards that were found, which, according to the state's theory, the person who's involved in Mr. Gutierrez's disappearance would have had to touch, to take out of the wallet, to put in the freezer. And they also didn't process the handle of the freezer. It's also critical that there was no blood on the handle of the freezer. And the phone, interesting enough, the DNA, they send the swab that they took to the crime lab, and it comes back and they say, yep, it's Mr. Gutierrez's DNA on the phone, but there was something that's called a trace allele. And you'll hear from the DNA expert that a
Soloman
trace
explained
allele
this.
means that it's someone else's DNA.
He already
that it's
has explained
a portion of someone's DNA that did not belong to Mr. Gutierrez, but someone else. And you'll hear that that trace DNA that they found on that cell phone, as I just said, did not belong to Mr. Gutierrez. It did not belong to Ms. Patterson, the individual who found the cell phone, and it did not belong to my client, Mr. Zachariah Anderson. So someone else's DNA is on that phone. You'll also see pictures and hear testimony about how the furniture in Mr. Gutierrez's apartment had been moved. And all of this furniture had been meticulously moved. Nothing's knocked over, nothing's broken. The kitchen table's nicely pushed back. The 2 white tables that were in front of the couch were nicely moved to the side. The couch had been moved, and we can see that because there's indentations in the carpet of where the couch had stayed for a long time versus where it was now. There were no bloody fingerprints.
Every time I look at her face, it gives me, number 1, nausea. Number 2, she's just sitting there thinking, huh, I dodged a bullet here. This is horrifying. And I just, this is awful.
Or hand marks on the bottom of the couch. They didn't process that for DNA in that area of a couch where the person had allegedly moved it, would have had to have touched. They didn't process the areas of the chairs that would have needed to have been moved, the table that would have needed to have been moved by the person who's allegedly responsible for the disappearance of Mr. Gutierrez.
Look at her shaking her head. She's like,
They
oh no,
also
that's
didn't
not how we
process
did
the
it.
tools that appeared to be nicely laid out in front of the screen door. Nor did they process in Mr. Gutierrez's bedroom the open window. They didn't process that for fingerprints. What did they do? They processed the blood. That was it. Law enforcement's failure
I might need to get it.
investigate
I might need
leads
to
and
get the body language guy,
effectively
Jesus Enrique Rosas, in
process
here.
a crime scene is critical in this case. There's no body, no human remains.
No body, no crime.
No murder weapon, no witnesses that can tell you exactly what happened. Yet they wanted to go with the narrative that it must have been Mr. Anderson, and that was someone that they looked into everything possible. They ignored everything else. They ignored the idea that it could be anyone else other than Mr. Anderson. And you'll hear that they meticulously searched Mr. Anderson's property, not just his house, his whole property. No body, no human remains, no evidence that there had been a huge cleanup at a crime scene, no murder weapon. Not only did they search his house, they also searched his family's tree farm, an 80-acre farm, top to bottom, multiple law enforcement agencies, every acre, no body, no human remains, no murder weapon, no evidence of a crime scene cleanup. They also searched Miss Susan Brown Williamson's home, and that was the place that Mr. Anderson had gone in the morning to work, that the state claims is where Mr. Anderson, I guess, chopped up a body and put it in bags They searched that property meticulously, not only the house, but the entire grounds. No body, no human remains, no murder weapon, nothing. Nothing of evidentiary value. They then searched all of the bodies of water that were near that home and Mr. Anderson's home. Not Lake Michigan, but quarries and little lakes. And they had technology that could go all the way down to the bottom to see if there was anything there. That search also revealed nothing. So the person they chose as their main character, the only person they investigated in this case, they did all of that and it yielded nothing. Mr. Anderson, as he sits in front of you today, is presumed innocent.
Because he is innocent.
And he must stay that way. Because the evidence in this case, as it will come in through this trial, will not establish that Mr. Anderson committed the alleged crimes beyond a reasonable doubt. And for that reason, when the defense comes and speaks to you, when the evidence is done, we will ask that you return the only just verdict, and that's a verdict of not guilty. Thank you.
Okay, I think we're done with this. Here's a question. I'm not even really sure I want the answer to this at this point because it might make me even more nauseous. How long was the jury out for this? Please tell me it was at least pondered and wasn't the McJustice system that we've become accustomed to. All right, so it looks like we are done with opening statements. Just in time to go over to Sal's live stream or go bake some cookies for some Christmas cookies. I don't suppose we can send, from what I heard, we can't send him gifts. We can send him letters. We can send him gifts through on the website. Here, let me show you. Day and a half. Has any of the jurors ever been interviewed with the media? Not like, okay, so for those of you, you might understand this phrase, we are the news now. I trust no mainstream media at all. Frankly, they're contributing to this problem of injustice in these trials. Oh, goodness gracious. There's been there's no jurors with loose lips. That's interesting. Huh. Maybe Crime Spies, maybe as a small channel, might want to, innocently reach out to some of them and see if they'd like to, if they would like to discuss, was it one holdout that just finally, caved and said, oh, I need to get home. Adding the jurors. Huh. I am in Minnesota. I don't know how far away that is. From my understanding, I think it's on the other side, which is like a 6-hour drive, 8. Okay, just wanted to show you. And then we're going to go watch Sal. And then if you'd like to join me in 2.5 hours, I'd like to at least get a jump on some of these witnesses. And again, I know you have Christmas and your families, etc. I'm kind of winging it with the times right now because I'm not sure. But I really want to watch this. So I appreciate you being here. But you might be seeing a lot of me. I might have my mud mask on, wrapped in a blanket, putting paraffin wax on my hands because I just want to watch this. I did want to show you this, and then we're going to go for a couple hours. You can go bake your cookies. You can go get some stamps so you can write Zachariah a letter see, hopefully, let me look and make sure. Okay, yes, you can see this. All right, so on the website here, copy, paste. All right. Okay, that's the link I'm on, the page I'm on. So it says all envelopes and packages must be labeled with Zach's full name, DOC number, and return address. We suggest also writing your return address on the body of your letters or cards if you wish for Zach to reply. He replies, can we send him stamps? The physical letters are processed through a service called Text Behind in Maryland and then sent to Zach in Wisconsin. They color photocopy the original content, shred the originals, and forward the photocopies to the correctional institution. It has been averaging anywhere between 1 and 4 weeks for Zach to receive the mailed letters. Letters and greeting cards must be mailed to the address for, okay, so in that link I just popped in your chat on YouTube, and I will on Rumble and Kick in just a moment. Here it is. And then here, this periodicals, books, textbooks, magazines, subscriptions, and newspapers can be mailed directly to the Correctional Institute, but they must come direct from the publisher and contain a packing slip. So if you want to send, oh, I know, I should send him the real Anthony Fauci book. I have, oh my goodness, I'm choking. I have that audiobook on my Rumble channel. It's 28-hour audiobook. And we did it in 1.2 times speed. It's 22-hour audiobook. But I should send him. That is the best book I've ever read in my whole entire life. It goes through so much. The AIDS epidemic. It goes through how your government has. It's unbelievable. It goes through like all the experiments they've done on people. It's the best book. Nonfiction book I've ever read. Okay, so I think maybe I'll do that today. Okay, so they don't offer alternative fastive mailers. Okay, so make sure you're reading through this. Oh, someone mentioned this yesterday. Text Behind does also offer an alternative and faster method of sending mail, which is accessed either through their website or by downloading the Text Behind mobile app. Generally, the text cards and messages are printed and shipped to the facilities within 2 to 10 business days. However, this service does come at a cost to use. It can be found at this link. Prohibited items. Okay, so don't send this list here. Inappropriate photos. I think that's a given. Greeting cards that are musical, pop-up, contain glitter, have multi-thickness, or have items glued to them. Oh, okay, I guess I'm not going to send him one of my Costco cards. Gift cards, cash, or personal checks, anything classified as contraband. See the Wisconsin Department of Corrections General Info page at the bottom of the page for more info. This is the last part. He can receive funds through Access Correction Service, Deposit, and their affiliate. So here's that phone, postal service, where I want to get to the part where, here, this is the bottom of the page. So ordering property for Zach. Please do not order without first consulting with his family. Any items sent beyond his allowable limits are required to be destroyed or returned at an expense to Zach. So we don't want to do that. Zachariah's brother, Soloman, has been in our chat. The state of Wisconsin has multi-vendor contract, blah, 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 for hobby and personal property purchases. All items through these vendors are considered safe and appropriate and do not need additional permission from the prison. So here's the link. These two links here at the bottom. It's my understanding that those are good. Oh, hi, Soloman. So, like I said, I'd like to scoot over to Sal's Saturday live stream. And for those of you who've never seen it, it is fantastic. And And then we will start another live stream at 3:30. I've invited my sister from another mister, Chrissy, to join us on screen, and we're going to start the witness testimony this afternoon. I hope that sounds good. I cannot redirect you because apparently I need 500 subscribers. But there, Stray. Look at that, Stray. She's got the link in the chat. It's like she read my mind. Alrighty. So I'm going to give you the outro here. It's only 30 seconds. Make sure to pay attention to that feather that's barely hanging on to Lady Liberty, because that is how fragile we are from losing the justice system our founding fathers intended. All right. Merry Christmas, everyone. Hopefully we'll see you later today, and I haven't decided tomorrow what time, but I'll figure it out. Goodbye, God bless, and free Zachariah Anderson. Okie dokie. And make sure to send him something on that. We'll figure it out. We'll talk later. I could ramble forever. Okay. Goodbye.